Thank you for joining us this evening while we talk about the different roles that are involved when someone protected by a union feels that that a violation has happened in regards to the collective bargaining agreement. We're going to talk through 10 different cases. The first case that we're going to talk to, next slide, is going to be in regards to maternity leave. A female employee adopted a baby, requested maternity leave, was denied the maternity leave, and advised that she would need to take a reasonable purpose leave. Well, if you look at the definition on the slide, as a maternity leave is defined as an absence of a female employee granted for the purpose of giving birth and taking care of her infant child. Well, while she may not have given birth to this child, she does have to take care of this child, and there is an importance, as outlined in the slides, that she needs time to bond with this baby. If the contract provision states that maternity leave shall be granted at the request of the employee, therefore there was a violation of the agreement, and the female should have been approved for maternity leave. Next slide. We will talk about a situation where a senior employee was not selected for a leadership position. The contract provision says that they will give consideration to seniority. It does not promise that someone of seniority will be given a job. The individual was allowed to apply for the job, was allowed to be assessed, interviewed. It was decided that he was not the best candidate for the job. No violation took place here because the contract provision only states that they should give consideration to seniority. Had they not allowed him to interview for the job or post for the job, then maybe he would have a case. But in this situation, he had no case, and so it is my understanding that there was no violation that took place here. The next situation on the next slide that we will be discussing has to do with complying with plant rules, disciplinary action. We have an employee who was terminated and filed a grievance advising that there was a violation here. Well, if we take a look at what took place, this particular employee refused to comply with plant rules by failing to wear protective gear, was caught sleeping on duty, reading magazines on duty, was given a written warning and a suspension earlier on in her career. That written disciplinary action was still in place as it was not a year old, and the contract advises that the written disciplinary action is within the year. So the termination here was completely justified. On the next slide, we're going to talk about a situation where someone was discharged from Leach Industries. The Assistant Director of Human Resources did violate the agreement when she terminated Mr. Norbuck. She failed to discuss the shop steward she failed to discuss with the shop steward and the grievance committee. She failed to activate Section 2. When there is a difference in an opinion, she should call in an arbitrator. And in this case, Mr. Norbuck and Ms. Napoli, they were in a disagreement on whether or not, he should have been terminated based on the fact that he did not reveal his college education on his application. Therefore, let's go to the next slide. The next slide talks about what I wanted to talk about a second ago with the after acquired grievance. Mr. Norbuck did not put on his application that he had a college education, but in no way did this impact his job performance. And the after acquired evidence can only come into play if the employer can show that they would have fired or not hired him in the first place. All right, next slide is going to talk about failure to comply with policy and procedures. This is dealing with the town of Stevenson. Officer Vincent had been employed with the town of Stevenson for 4 years. She knew that she could be called into work to cover shifts at any time. She did not have the proper childcare in place that would allow her to report on an order back or a call back. She was called in. She failed to show to work because she couldn't find childcare. So she was placed on a suspension. The suspension is justified. If you look at the callback method, she's been with the company for 4 years. She should have known that she could be called back and should have a plan A and a plan B for childcare. It was suggested by the union grievance that it should be considered sick leave. Well, the provision in in Article 8 in Section A1 defines sick leave as someone being unable to perform duties because of illness or injury. And in this case, there was no illness or injury on her behalf or her children's behalf. Therefore, the suspension is completely justified. The next case we're going to talk about is Saga Food Service, where someone thought they should be paid holiday pay. In this situation, the individual did not show up to work the day after his scheduled holiday, and the provision specifically says that he needed to work his full scheduled work day immediately before and immediately after the holiday. Well, he did not come in on Wednesday. His holiday was on Tuesday. Therefore, he did not comply with the provision, so he should not be paid holiday pay. The next case we talk about, there was an escalation of a situation between a supervisor and a first-line employee. Some profanity took place. The employee was terminated. The article explains the grounds for temporary suspension or discharge: insubordination, boisterous talk, profanity, horseplay. During the trial period, it was revealed that, no doubt that the individual used profanity toward his supervisor. Therefore, the termination was completely justified. It did follow the provisions outlined in the articles. We move on here to where we talk about subcontracting on the next slide. Bangs Manufacturing Company, case number 8. They opted to quit making their own pulleys, and they opted to subcontract that out. They, in a specific part of the article, pulleys are not specifically discussed, and the statute here does not justify a contract of sale. It meets the definitions of a contract of work. So the company was completely within regulations to go ahead and subcontract the work out. And then we talk in case number 9 about a decision made by an arbitrator in regard to Mr. Davies, who was released from his employment, and he felt like he should have been called back as a racker. Although he had never been classified as a racker, at some point in time he held a position of a head sawer, but he was demoted to maybe a saw helper because he was no longer being paid at the grade of a saw helper, which would have been equivalent to a racker. And there was no reason that he should have expected to be offered that position. And then the last case we're going to talk about is the city of Ditchburn, where they moved a senior employee to another shift. He felt like he was done wrong because he was a senior and he should not have been moved to a third shift. He didn't want that third shift. But we saw in Article 6 the management rights, and we see in Article 10 of Section 4 that the department head reserves the right to the final determination regarding employee transfer, shift, assignment, days off, and vacation time. So in conclusion here, we've talked about some different roles in an organization or leadership union. These roles are involved in the negotiation and decision-making process when a grievance is filed. I hope this has been helpful to you to help you understand some of the different roles that are involved whenever a grievance is filed, claiming that the collective bargaining agreement has been violated. Have a good night.